and I want to thank Sedgwick for sponsoring last year's webinars as well as this year's webinars. We appreciate their support. Um, my name is Ken Ross. I am the webinar coordinator for SPSP, and appreciate you all participating and attending, and hope we're doing something useful here, and we'll do more useful programs as the year goes on. Next slide. We have 3 programs coming up in fairly short order. Um, we're doing next week. We're doing one next week rather than each month because Virginia Tech has come out with this new risk assessment tool that sort of relates to today's program, and I wanted to give them an opportunity to show it to all of you because it is available to people to use in the future, and I think it'll be very interesting for you to see the new developments there. And that's January 29. Then February 5 was our February program, and we're going to talk about foreign language and translations and how to format instructions so that people can see the different languages you have. So we've talked a lot about instructions in the past. So this will be related to that, and we'll talk about the foreign language part of it, which is a very interesting topic, both from a legal standpoint and a practical standpoint. Then we'll take an ICFSO break. And then in March, we're going to talk about retailers and manufacturers. We did a program last year on this subject. I've got two new retailer representatives to talk about this. And we'll continue the conversation, which again is very important since we all are in this game together, and we need each other to collaborate on providing safe products. I don't have it on the list, but just to let you know, in April, I've got a CPSC trial attorney who's going to talk about reporting issues and how to create adequate corrective actions that will be approved by the CPSC. In May, I don't have these on here because I don't have exact dates yet. In May, we're going to do managing cross-border recalls. So how to do a recall or a corrective action in multiple countries, which I think is very important. And I believe in June, we're going to do, we're thinking about having acting Chairman Feldman from the CPSC be interviewed in June. I think we're thinking about June, maybe later. We'll see. And then one other program that I'm working on is optional safety, post-sale safety improvements, which are very interesting topics from both a risk assessment, a design, a legal standpoint. And on that panel, I'm going to have a patent lawyer talk about how you write patents when you talk about safety without creating big problems for yourself. So those are the things we're thinking about in the next few months. And we appreciate you paying attention, and you'll be getting announcements, and I'll be putting these in the newsletter this month that talk about the upcoming schedule. Next slide. So here are today's speakers, Don Moffat and Geraldine Cosh. And I can say without exaggeration that these two are some of the most experienced risk assessment folks in the world. They've been doing this for decades. They know they've done them. They know what's required. They know what's going on, and they have great information for you today. Next slide. Now, we're not going to be getting into this is not risk assessment 101 because we assume you know generally what risk assessment is. So we're going to talk a little bit about the legal basis of it, pre-sale, post-sale risk assessment. And when I think about the design of a product and how we're developing a product, selling a product, it's in the marketplace, we're having problems after sale, and we're having accidents. Risk assessment really is involved in either a formal or informal way throughout the entire process. We're always evaluating risk. I used to say in talking about risk assessment that I do a risk assessment when I get out of bed every morning. I'm thinking about, let's see, what's going to happen to me today? So risk assessment is just a normal process of the entire manufacturing sales use process. Now, Geraldine and Don are going to talk about it, the more formal part of it, but it really is involved throughout. I mean, we're always evaluating risk, minimizing risk. We don't want to take risk that we don't want to. I guess driving to the supermarket, I mean, I'm doing a risk assessment. Which way do I want to go? How fast do I want to drive? These kinds of things. So before I turn it over to Don, who's going to talk about the legal, the regulatory requirements in the U.S., and then Geraldine will talk about it in the European sense. I just want to mention, as both a product safety lawyer and a product liability lawyer, just mention the product liability piece of it, as I have experienced over decades of doing this. Risk assessment is hated by trial lawyers, by defense trial lawyers, because they say they can never defend the adequacy of a risk assessment. And they would prefer, they're somewhat facetious about it, they would prefer manufacturers don't do risk assessment. So, because I've never had one that ever helped in defending a case. Well, the reason for that is because if a risk assessment is done, it gives a roadmap to the plaintiff's expert to criticize what you did. And whatever you did is going to be inadequate. They will always criticize you for doing it. So if you do it, you document it, and it's in existence and it relates to the product that is being challenged, they're always going to find something to criticize you for, something you could have done differently, better, more analysis, whatever they're going to say. So that's why litigators, would prefer you actually not even have it anymore because they're hard to defend. Well, from my standpoint, particularly as a safety lawyer, you have to do a risk assessment. You have to document it. You have to keep the documentation, I believe. And you just have to do it in a way and write it in a way that you think you can defend yourself, that you can explain to a judge, a jury, a plaintiff's lawyer, a government agency, why you believe that the product that you came up with is reasonably safe. Not absolutely safe, but reasonably safe. So we think about it in that way. I think about it in that way, and shouldn't be scared to do it, scared to write it down. Understand that you could be criticized later for what you did, and just have a story about why you came out with what you did. In my experience, I believe that if it's a well thought out risk assessment, well documented, then most of the time the plaintiff's experts and attorneys are not even going to challenge you on it. They're going to let it go. Now they'll come up with a safer design for you, but they will probably leave alone the risk assessment and try to get in and nitpick the whole thing, every aspect of a risk assessment. So don't be afraid to do it. Write it carefully. Anticipate that you might be challenged on it later, and just have a story that looks like you're a good and careful company that tried to do the right thing. And I think more often than not, you'll not have any problem with this. But understand that you could be challenged on it. So we want to talk today, though, about the regulatory requirements and the different techniques that are out there in risk assessment. So with that said, I'm going to turn it over to Don and be quiet and let the experts talk about risk assessment.
All right, thanks, Ken. Yeah, so let's talk a little bit about the U.S. and what are the requirements in the U.S. Well, the simple story is there aren't any as it relates to risk assessments. Now, with that said, CPSC, Consumer Product Safety Commission, has been around since the early 70s, right? They came out with the Consumer Product Safety Act, which is actually the legal basis for product safety in the United States. But even after all these years, after 50 plus years, they still haven't gone to the point of actually requiring a risk assessment. It's not in their language, it's not in the lexicon. But what you can do is you can pick apart areas of what the CPSC has published and kind of understand how they do look at things. So when you look at the Consumer Product Safety Act, there's a lot of different elements to it. But some of the ones to keep in mind is things like Section 7, where it actually allows the CPSC to rely on voluntary consumer product safety standards and actually enforce them as though they are law. So that's something to think about from terms of a risk assessment, is they know that they can't keep up with the laws on certain things, and they do refer to other places. That's something that you have to consider in a risk assessment, even though they aren't explicitly stating it. But one of the parts that to me is really the most telling part of US law is when you look at Section 15D, where it talks about the Commission's ability to order companies to remove unsafe products. And in their analysis, they actually have defined the term substantial product hazard, and it has two meanings. One of them is a product that doesn't meet the law, right? So that covers their issues like lead paint or other requirements where they actually do have a law written. But it's really their second definition that everyone should be opening their eyes to, which is a product defect which, because of the pattern, number, all these different variables, creates a substantial risk of injury to the public. That right there is almost the very definition of a risk assessment. So one of the things to realize when it comes to the US is while they don't have a written requirement to do a risk assessment, when they are evaluating whether or not a product is unsafe, they are conducting a risk assessment on that item. So in essence, they're implying you should probably do that before they're doing it on the back end. But one of the great things about this now is even though the CPSC has been around for 50 plus years and they haven't done a good job of driving towards risk assessment, Europe has, right? So there's a lot that we can learn about risk assessments on the other side of the ocean. And that's where I'm going to hand over to Geraldine, let her talk a little bit about what we can learn from Europe and all the great documentation and processes they have.
Great. Thank you so much, Don and Ken. It's an absolute pleasure being here with you this evening or this morning, whatever time it is. So I can't talk about risk assessment without talking about the GPSR, right, Don? I don't know about for you in the States, but here in Europe and in GB in the UK, it's been quite exciting. I guess it depends what excites you, right? But it's definitely excited me and the colleagues that I work with and also the clients that I work with, because this has been a significant piece of legislation that came out last year. It was like an early Christmas present. It was December 13th.
Can I interrupt just to say GPSR, General Product Safety Regulations?
Yes, the General Product Safety Regulations, and using acronyms without explaining it, how terrible. Thank you for that, Ken. So yes, the General Product Safety Regulations, they came out December 13th. It was Friday the 13th, which is a little bit funny in itself, but I'm sure you've seen the great webinars. So I know that Rod Freeman and the team did some webinars, and there's some really great information out there. But that's definitely shifted towards risk assessment for all products fundamentally. Like Don has already explained and started to explain there, that it's implied in the law sometimes. It's not very clear, but it's quite clear in the GPSR that they're saying that you need to do a risk assessment. So there's an FAQ document. If you go to the European Commission website, I will put some links in the presentation before it comes out. But there's an FAQ document, and in that document it says, do businesses need to perform a risk assessment for all products? And fundamentally, the answer's on the slide here, and I know you can read it yourself, but the answer is yes. So what they're saying, in a long-winded way, is when placing a product on the market, the manufacturer must ensure that the product's safe. Quite similar to what you were talking about, right, Don? So it's safe, and then if it's unsafe, then what you need to do. So in order to do that, in order to ensure that your product's safe, you need to do a risk assessment to do that in the first place. So the GPSR, the General Product Safety Regulation, does not prescribe how to do this, which can be a challenge, but it's also an opportunity. So there's no specific prescribed method on how to do this risk assessment in the GPSR, the General Product Safety Regulations, before you put the product out on the market. However, this framework has always been here. So with toys, for example, under the Toy Safety Directive, there was this concept of safety assessment. So in my opinion, it's a similar kind of thing, which is basically a risk management document. So if I have a product, I'm looking at the product, I'm looking at the potential hazards, I'm looking at how am I going to manage that risk. And one of the ways of doing that is by following standards. So if there's existing standards out there, or you can do something called standards by analogy. So what we mean by that, if it's not a toy, for example, but you want to assess sharp points or small parts, then you can use the toy standard, even if it's not a toy. So that's just some things to consider. So also it mentions Article 9, which is the obligations of manufacturers. So within the laws, you can see the breakout of the way they're set out, and it has the obligations of the different economic operators. So if you're a distributor, a manufacturer, and they're saying here, before placing their products on the market, manufacturers shall carry out an internal risk analysis and draw up technical documentation containing at least a general description of the products and its essential characteristics relevant for assessing its safety. So I hope that makes sense on what I'm explaining about the GPSR and where it talks about risk assessment. So you need to complete one, especially for general products. But there's also other products that are CE marked, for example, toys. There's been a requirement around for that for a long time. So an important concept that we mentioned in the slides before is this concept of due diligence. And I also can't talk about risk without talking about PAS 7050. So PAS 7050 is a document that was released by the British Standards Institute. It was sponsored by the Office of Product Safety and Standards, known as OPSS, and it's about bringing safe products to market. So it works alongside another sister standard called PAS 7100, which is about recalls and corrective action, and we will be talking about that as well today. And there are documents on recalls and corrective actions in the US, right? On the CPSC have got a document on recalls. The European Commission has a document, but there are no documents like PAS 7050, in my opinion, about, well, what do you do up front? What do you do when you're bringing products out to market? And within that document, it's got loads of great information. Again, I'll put the links in the presentation when we send this out, so you can download it for free. British standards are not always free, so this is great that it's free to download. But in Annex G of the PAS, it talks about this concept of due diligence. And you can see it here on the slide, and you can see it in the annex of the document. And my favourite bit about it is the last bit here, the last point. So the broad principles, they've been set, there is a precedent set in cases. And normally what they're saying is sitting back and doing nothing is normally insufficient. So if we go back to that situation that Ken spoke about, kind of introduced, imagine you're in a court situation and somebody said, well, what did you do before you placed the products on the market? You say, well, didn't do anything. So here in Europe, say it's not CE marked product, it's a general product, there are no standards, so I'm not going to do anything. That's not really going to work compared to, well, actually, I looked at the product, I looked at the potential hazards or risks that it has, and I took these mitigating steps. For example, I tested it to EN71 or ASTM F963. So I hope that makes sense with that. And the concept of due diligence is a really, really important one. And also to the point that Ken was making, if you're standing in court defending your risk assessment, you can't stand there and say, well, we decided it was low just because we felt like saying it. You need to explain and document why you came to that and why did you come to the probabilities or the estimations that you have in your risk assessment, which we'll briefly talk about when we're looking at PRISM. Okay, so let's look at pre-sale versus post-sale. So the GPSR really talks about before you put the product on the market, you need to do this internal risk analysis. And then post-sale, there are actually methodologies released. So remember with pre-sale in the GPSR, there's no method. They haven't given us any documents yet. You never know, we might get something which will be great from the European Commission. But at the moment, there's no template or document to use. But there are some documents that we can use post-sale, which I'll come on to in a moment. But I just want to clarify this concept of pre-risk assessment. So I've got RA on the slide there, risk assessment / safety assessment. That's because it's a little, I'm a little bit bothered by the term risk, to be honest, because you don't come out with a risk level. So we've got the pre on the left and then we've got the post on the right. So what's the legal obligations for pre-risk assessment? We've already spoken about that, right, Don? What do you think about the legal obligations in the US for pre-risk assessment?
Yeah, from a risk assessment standpoint, the US has no requirements on either end. It's implied, right? The government implies that you should have low risk. The only way to do that is through a risk assessment. The only mention of terminology with the risk assessment is basically what the CPSC is going to do and evaluate your product to determine if there's a substantial product hazard.
So
Can I interrupt for 1 second
yeah,
and ask a question? I heard this morning from another source that the EU is going to come out with a guidance document on GPSR. Is
yeah.
that correct? And it could be this month or next month. And the expectation would be is that they would talk a lot more about what kind of risk assessment is necessary. Is that your understanding?
It would have been a great Christmas present if it came out before Christmas, because I've been waiting for it since December 13th. So
Okay.
hopefully they do, but they haven't. They've come out with an FAQ. They have made a website. Again, I'll put it in the slides and you can see it for businesses, which is great. And they do have a webinar, which I believe is next Friday that they're doing, but we haven't seen the guidance document yet, and we are hoping for it. So it would be great if we get it, but
Okay. I just wanted to point out, just wanted to be sure that people knew there will be more information coming out, which should, give you more guidance on what to do. That's all.
yeah, hopefully. So yeah, I think we've spoken about, and please do feel free to interject with any questions, Don or Ken. So really, pre-risk assessment, before I'm putting the product on the market, what am I going to do? Have a look at the standards that are out there. You can do lots of things that are in the post-risk assessment that we'll talk about. Look at injury data, look at your complaints, etc., and do a risk management document. So if we've got small parts, laceration, etc., let's try and mitigate that, and we'll talk about risk management. There is no method, and you don't really come out with a risk level. What I mean by that, let me explain. If we did a risk assessment on trampolines, I feel, in my opinion, it would probably come out quite high. Now, I know, according to the standard here, you have one at a time, go on the trampoline. And I think fair play to any parent or caregiver that has stood on a trampoline and said, right, one at a time to the children. I know that I've let my 2 kids, 3 nieces, and a dog on a trampoline at the same time. And I know I shouldn't, because I'm doing a risk assessment. And really, the concept that's coming to my mind is tolerability that we're going to talk about. So you probably wouldn't release the trampoline because it would probably come out high risk. So there's no risk level when you're doing a pre-risk assessment. It's a risk management document. I hope that makes sense. You don't usually come out with a risk level. And if you do, how helpful is it really, if that makes sense? So if you want more guidance, have a look at PAS 7050. So post-risk assessment is where you've got a complaint. An authority's contacted you, someone in your supply chain is saying, right, we've got a problem here. There is a legal obligation. In Europe, if you have identified a serious risk, you need to take immediate action. Now, what you do with that and how you do it, and, specifics around it are quite vague. But from a market surveillance point of view, the enforcement officers, they are expecting quick action if it's a serious risk. So there are some legal obligations around that with post-risk assessment. So the European Commission developed Decision 2019-417. It's on the slide. You can put it in your search engines. Again, I'll put it in the links in the chat, not in the chat, sorry, in the PowerPoint when we send it out. And you can go on to that specific methodology in Decision 2019-417. What they did in 2024 is there's another guidance document around that, regulation. So it's not a guidance document, but they've released a regulation about post-risk assessment. And I'm going to talk to you about that in a minute. And then in GB, so in Great Britain, we have something called the PRISM methodology. So I think you're getting the point now. There's quite a few methodologies that we have here in Europe and in GB. There's more information on that in PAS 7100 as well, which is the document I mentioned earlier on. Again, free to download.
Geraldine, one thing that I wanted to comment on with that is when you're looking at doing either a pre-sale risk assessment or a post-sale, from a pre-sale standpoint, I fully agree with Ken. You're going to run into people that don't want the documentation, but documentation is your friend in order to show due diligence. While I'm not an attorney, I've worked with enough attorneys to know that it does help. You may lose a case based off the documentation for missing something, but punitive damages may be lesser if you actually showed that you did try something. You may have missed something, but you didn't do nothing, right? So I'm a huge advocate of pre-risk assessments. Document it, just make sure you don't have those smoking guns of saying, oh yes, this is a serious risk, and then you do nothing about it, right? That's the key to pre-risk assessments. But the post-risk assessment, the one thing that I want to caution everyone on also is if you're doing a post-risk assessment, either because you're aware of an issue or maybe you're late in the game and you're just catching the company up and you want to start looking at things, you have to be really, really careful because you now have products in the market. And if your risk assessment comes back and says there's an issue, you now have a time clock clicking for you that if you wait and keep waiting as it's being talked about and discussed, every single day starts building up more and more punitive for why didn't you take action sooner, right? A lot of companies will do post-risk assessments using outside third parties through attorneys in order to provide attorney-client protection. I have to advise that, right? Because you are at risk if you're doing post-risk assessment and if you're not able to act immediately on it. So those are just some observations in my years of experience of both of those, some guidance I can give on the importance of pre and post sale.
Yeah, I totally agree. And I've had people that have asked me to do risk assessment, and the risk assessment, according to these methodologies, is not quick. And I'm not sitting here, bored, waiting for someone to contact me. And they're like, let's wait and see what your risk assessment comes out. And immediately I'll say, no, there's stuff you can do now. There's investigation, FMEA, isolate stock, find out what there is, where they are. And it does depend. It's all case by case, right? If the product's even released, maybe it's not even out on the market yet. It's, it's on the water. We don't know. So there's a lot of things you can do while you're doing the risk assessment as well. So let's take a look at some methods, and over to you.
All right. So one of the things that we can learn from the CPSC, like I said, they don't have requirements out there for risk assessment, but within their recall handbook, within the CPSC's recall handbook, they actually give us the roadmap for a risk assessment. For them, it's evaluating the substantial risk of injury. And to do that, they give us guidance. They talk about the pattern of the defect, where the defect may stem from. They talk about the number of defective products that are out in the commerce. Again, these are variables within a risk assessment that must be factored into. And if you go on to the next slide, the other element is what is the severity of risk? And now what's interesting is CPSC, their recall handbook back several years ago, actually broke down the severity of risk and the likelihood of injury into two separate concepts, but now they've actually combined them together. And I get it. I mean, risk, you have a lot of variables, some of them combined together. The important part is that you're thinking about each of these variables. So while the CPSC does not have a specific method that says, here's what you are required to do, and here are the steps to do it, they're starting to give the roadmap of how to think through a risk assessment. But again, one of the things that I love within the recall handbook is they have pages and pages about all of this. And then almost as a footnote, they say, oh, and also a substantial product hazard exists if you don't meet a standard. So that right there is one of the most telling things that says why you must do it. Even their own handbook and even their own documentation pretty much clearly observes meeting a standard is obvious. All of this stuff is for products that meet the standards or don't have a standard. This is how you need to think about it. But again, this is another area that we can look over to Europe and see a lot of the documentation that they have, that they've really been building this out, and we can learn from that and build off of that. Now, the one last thing to look at when we're looking with CPSC, if you go to the next slide, is what do they do with that information, right? So it's not just a matter of, okay, now we have this knowledge, what do we do? The CPSC does classify those hazards as they're going through all those different things, the severity of the risk, the likelihood, number of products, all of that, is they start to classify the hazards into an A, B, or a C. Now, the comments around these, so the Class A hazard definition is the hazard directly from the CPSC. I put in here my own assessment that if you have a Class A hazard with a product, that's typically going to result into a product recall, right? Unless there's some obvious issue that won't do that, most Class A hazards with consumer products are going to result in a recall. Class B hazards, though, is where you get the 50-50. They might lead to a recall, they might not lead to a recall, and most Class C hazards will result into a more minor issue and are unlikely to be a recall. But keep in mind, CPSC doesn't say this. They can absolutely issue recalls or issue substantial product hazard notices and do an evaluation against it and force a recall on something that is a minor hazard, but maybe is a larger risk based off the variables. So how you classify these is really important. Every hazard is not the same. You have to understand the risk behind it. And this is where you get into risk, is thinking in terms of the severity, likelihood, and the other variables.
Can I interject one thing here? In my experience, I can't guarantee it's never happened before, but usually the CPSC will not tell you how they classify the hazard.
Correct.
So they'll classify it as an A, B, C. There's actually a Class D hazard, which they don't tell you about also, which means that they don't think you even have to do anything. That no recall is necessary, that it's such a minor risk. So, but they don't normally tell you this. Sometimes you'll find it in documents that you get from the CPSC later on. So normally they'll just help you figure out what they do, but they don't normally tell you what that is.
Yeah, good point. So I'll hand it over to Geraldine to talk a little bit more about Europe and what we can learn from them.
Perfect. Thank you, Don. So this is the PRISM risk assessment methodology. So as you can see on the slide, it's the product safety risk assessment methodology and known as PRISM. And it's a guide for GP market surveillance authorities. And I think that's important. So this document, the decision I mentioned earlier, so decision 2019-417, and also the regulation that's now come out in 2024, are written for market surveillance officers and authorities. So they are the enforcement officers. However, that's not stopping businesses using these documents as well, even though there's nothing specific for businesses. But I think it's really important to understand the context of how these are written. And they are actually a decision-making tool. That's what they're for. They're for market surveillance officers to use as a decision-making tool. So this is a slide that I could spend probably 2 weeks talking about, or 2 minutes. So I'm going to try and cap myself, because I know we haven't got long left of the webinar. There are some free 4-hour sessions that we are running actually on this topic. It is earlier in the morning in UK time, but there are recordings available. And again, I will put the links for that in the PowerPoint that we send out for you. So you're welcome to join those sessions in February and March. And it really goes through this in deep detail. But the process flow of PRISM, first of all, is the identification of a non-compliant product. So it might be non-compliant. It might actually comply with some standards, but still be unsafe. And then there's a risk triage. So I don't know if you have this when you go to a hospital in the US. For those of you that are here from the US, we have a triage system here in the UK. In London, if I go to the hospital, there'll be a triage nurse that will then decide, right, who do I need to see first? And that's basically what the triage system is saying here. Right, how do we prioritize this? How is it important? And then the actual risk assessment methodology, the third part here, is basically exactly the same, very, very similar to decision 2019-417. So the EU methodology that came out in 2019. So it's really, really similar. Then there's the risk evaluation, and then there's the quality assurance and risk management. Just to briefly mention, my favourite bit actually is the risk evaluation, because this is about tolerability, and I'll speak about that in a moment. The bits around the risk assessment is probably what everyone was doing anyway, but they just weren't documenting it. And as we've mentioned already in this webinar, it's really, really important that you document it. When I did an expert witness course, one of the things I learned was if it's not written down, it didn't happen. So if you haven't got it written down, what you were doing, then if it goes to a court situation, it'll assume that nobody did anything, which is not a great position to be in. Quality assurance is vital. And that is working with your colleagues. Whenever I do a risk assessment, I have a colleague who will take it, rip it apart, question me on it. And that's great to have that. I also have a paediatrician that I work with if I do risk assessments that involve children, and he'll check it as well for me. So having that team around you to check it, doing that QA. And then risk management is vital. So what are you going to do? Now that you've identified maybe a risk, or maybe it's a low risk, does it mean you don't do anything? It really is case by case. So let's take a look at this and break it down. So the triage process is here on the right of the slide. So first of all, can the product be deemed to present a serious risk? That's a really important question about the first thing that comes on there. They've actually released some examples of when things are considered serious risk. And I'm going to come on to those things in a moment. For example, chemicals. So if it doesn't comply with chemical legislation, so we have something here called REACH or CLP requirements, if it doesn't comply with that, it is automatically deemed a serious risk. And I'll explain a little bit more about that in a moment. So do you need to do a full risk assessment? In my experience, if something is a serious risk, you tend to know it. And you might not even need to go into doing a full risk assessment because you're like, this is a problem and I know it's a problem. But then if you want to, of course you can. So is a full risk assessment required? Is the risk triage? And you can see that there on the next slide. And then here is the risk assessment. This is the tough bit. Like Ken said, we all do risk assessments all the time. I do a risk assessment every night when I go to bed because I set my alarm because I know I won't wake up when I need to wake up. It's a risk assessment. Do I document it? No, because I don't need to document it. But it is important to document it when we're talking about product safety risk assessments here. So what we're doing, the process here, you define the product, you identify the hazards, determine who is specifically here. There's some specific information here that you follow, and the level of uncertainty. I think that's really, really important as well. And then you come out with a risk level. Then, is the risk tolerable to the public? So in my opinion, some of the biggest recalls that have happened in history are not necessarily serious or even high risk. They're probably low or medium. But what wasn't acceptable is the tolerability to the public or to the business. And this is where the risk culture of the business, so the risk appetite of the business, is key. And that's why it's important for me as an independent safety consultant, when I'm dealing with so many different businesses, they can't be all treated the same because they're not going to want to behave all the same. Some are willing to take more risks than others. So that is really, really important. As a business, define and understand what is the risk appetite of your business. Are you willing to have XYZ on your product? And some people are, and it depends what you're making. So for me, that is my favorite bit of the risk assessment methodology here in PRISM. You've got the QA and you've got the risk management. I also think that this should be step one. So straight away, can we do something to manage the risk? If you're at a stage where you're sitting and thinking we need to do a risk assessment and get it documented, there probably is something you can do to manage the risk. Isolate stock, get people doing an FMEA, whatever it is, there's probably something you can start doing to manage and mitigate that risk.
Let me point out, in a product liability case in the United States, the key question is, can you make the product safer? Risk assessment, by the process you're talking about, establishes, you've evaluated the risk, you've decided either to do nothing about it or to design it out or to add warnings or instructions. And that's sort of the key criticism that there can be, because it shows you the process you went through to come out with a reasonably safe product. So that's the thing that the trial lawyers kind of hate, is it just shows exactly what your thinking was and the decisions you made. So you're going to need to justify why you added a warning label instead of designing out the hazard, or why you just identified the hazard but didn't do any analysis on it because you felt it was too remote of a risk. So these are you have to do this. I don't know how you do it otherwise, but it certainly is a roadmap to being criticized for it. And I'm sure every risk assessment, no matter how good you do it, could be challenged, we'll say.
Yeah, for sure. And it's evolving. It changes. I've done risk assessments for people and, they've had one complaint come in. They've decided to just hold and wait and see. If all of a sudden they get 10 or 15 more of the similar complaints coming in, that's going to change the risk assessment. It will. So it's an evolving document. And the decision you made at the time when you had 1 versus 15, it's important to note that down and take notes of that. And this is why we did what we did. It's really important to have data. And this is one thing I love in the US, the CPSC. I'm obsessed with the National Electronic Injury Surveillance System. It's in the PRISM guide because we told them to put it in there. It's a really useful document, the PRISM guide, and it has a link of all of these resources that you can use. And this comes back to time. There's another way that we talk about doing the risk assessment quickly if you attend the 4-hour session. If you have the time to do research, have a look. There are some products out there that you think might hurt people and they actually don't. There's no data that it's actually happening. So data is so important. And if you say, well, we made that decision on that day because this is what the data was telling us, that's really, really powerful. So there's just some information here that you can have a look at, again, in the PRISM guide, which I'll put the link for in the presentation when we send it out. So quickly, because I know we've spoken about 2 methodologies. We've spoken about the PRISM methodology, so the Great Britain methodology. When I say Great Britain, that's England, Scotland and Wales. And then we've got Decision 2019-417. It's a decision, which means it's a recommendation. And then we've got this regulation that came out in 2024. Basically, the methodology is similar. It's the same. There are different tools that you can use. But if you went through the PRISM methodology and you went through the Decision 2019-417, you should come out with the same result. It's just that the PRISM methodology, as shown here, has more around it. So really, the EU method is just section 3, and then the rest of it around it is supported in the PRISM document. So I hope that helps, just to explain that. So the 4 levels of risk, there are a number of additional elements within it. It goes into depth, as we've explained. It talks about triage, it talks about multiple hazard, and individual product risk versus population. And there's also some additional things in the PRISM document. So people at increased risk, the use of data, testing and product homogeneity, relative risk, precautionary principle, which is a vital principle, which the General Product Safety Regulation has strengthened, the precautionary principle, risk perception and psychological harm. The new General Product Safety Regulation has brought in risk assessment for mental health risk, which I think is a huge challenge, and I don't even know where to start with that one. So that's also mentioned in PRISM. Just to highlight, as I said earlier, so things are considered automatically serious risk. Remember who these documents are written for. So they're written for the enforcement officers, the market surveillance officers. So if they have identified a non-compliance with chemicals, Category 3 PPE, so personal protective equipment, that's normally, if it fails, it's life-threatening. So that's why it's considered serious risk. And then they have this specific one, which is an angle grinder, chainsaw, disc and attachments. So any of these are automatically, under the PRISM methodology and the PRISM guidance you can see online, they are automatically assumed serious risk. However, it is rebuttable, so you can have a debate and a discussion about it. When we're looking at the EU, you have Decision 2019-417, and then this regulation that came out, they've released some specific information on what they consider to be serious risk. So if the risk is linked to a severity level of 3 or 4, which basically means death, or level 3 is where the injury lasts longer than 6 months. So if there's a potential for that to happen, then it's considered a serious risk. If they've made the product available on the market or an online marketplace and it's already been listed before as a serious risk, it's going to be assumed a serious risk. If it's been previously subject to a recall, withdrawal or removal of online, based on voluntary measures even, again, serious risk, or where there's well-documented evidence and it has certain features, for example, small parts for toys or childcare products under 36 months, highly flammable fancy dress, highly flammable nightwear for children, both of those items, childcare articles posing a drowning risk, drawstrings in the head or neck area for young children, and electrical products with defective components that can lead to electric shock or fire. And that was something that just came out in 2024. And that's something from the European Commission, that they will automatically assume that all of those things are serious risk. So we thought it was important to make you aware of that. Okay, and just to finish the session off now, we're going to talk about risk management. So there are certain principles with risk management, and the way to summarize it, we've got here on the slide. So there is a standard, ISO 31000, and that lays out the principles of risk management. And it can be explained in 3 steps. So elimination, can you eliminate it? Mitigation, can you mitigate it or put a warning? So if we're looking at trampolines, for example, eliminate it, don't have one. I don't have one in my house, not for safety reasons. I don't have a lot of real estate here in London. Mitigate it. Let's put the fences up around it. Might be a way of mitigating it, or warning is putting a warning, for example, one at a time on the trampoline. So that's examples of risk management. And that's something to think about when you're looking at risk management for your particular products. Don, do you want to explain a little?
Yeah, and while the US doesn't really have anything, again, the ISO standard lays it out really well. This list here is something that I've used in my training courses for several decades now, and basically follows the very similar to what the ISO says, is talks about your best option to mitigate risk is to design out the potential hazard. If risk is hazard times the exposure, if you drive the hazard to approximate to zero and you design it out, you have now effectively eliminated the risk. But that's not able to be done in all cases. So that's why these other levels are in there. But I think one of the important things to keep in mind, and I would imagine the ISO standard did this for the same reason. If you look at the order of the events, your best option is always to design it out. If you can't do that, then you look at the next levels, which is protect or safeguard, or in the ISO standards, to mitigate the hazard. If you think about Drano, drain cleaner, you can't take out the hazard that it's caustic chemical because it wouldn't work. That's why they put it in child-proof bottles, is to mitigate the hazard or protect or safeguard against it. Now, a new one that I got introduced to several years ago, I was doing some consulting for industrial companies, and they didn't do consumer products. They did products that were installed by professionals. And one of the things that they brought up and that they talk about is there a way to mitigate the risk where you train the individuals who are doing the installations to avoid the risk during the installation? And I thought that was a very novel concept. Another way of thinking about mitigation is, are you able to train? Now, obviously, with consumer products, not as effective, right? And that actually leads us into the final bit here, which in my opinion is the lowest effectiveness. There are tons of research studies out there that prove it, is providing warnings and instructions. So warnings and instructions should never be your first option to mitigate risk and to manage that. However, if the risk is low enough, there is a way to use warnings and instructions to try to decrease your risk a little bit further. It may help you in a litigation case, it may not, but when I say that, if in a litigation case you had a warning about something, but it was a really cheap fix to implement a change, you're going to be held accountable for it. A warning will not overcome a simple design change for that. That's why it's the last step. But it does serve in those areas where the risk is low enough, and possibly the requirement to design around it is either prohibitive, you can't do the product, or is otherwise just not feasible. But this should be your roadmap when you identify issues. These are the levels that you should be going through. ISO standard maps it out as well. Okay. So I think at this point, we hand over to Ken to wrap up for questions.
Okay, if you have any questions, submit them in the Q&A box. And Don, you can tell me in a minute if the question that did come in that you answered, I don't know if that went to everybody. Did the answer go to everybody? Do you know?
I don't know, but I can definitely comment on it. And Geraldine, you may have a comment.
Yeah, go ahead. Why don't you do that one, and I have a couple extra ones. Go ahead.
I'd like to know Geraldine's take on it also. Is the question that came in is, if you're selling a product that requires a CE mark and you legitimately meet the requirements to apply the mark, do courts in the EU interpret that as meaning that you performed an adequate pre-sale risk assessment? And what my response was, and I'll paraphrase, is, in short, yes, but no. Right? Yeah. There's a presumption of conformity when you comply with the CE mark, the requirements within that. But at the end of the day, the standards do not cover every single potential hazard with the product. And I can give you dozens of examples of toys that meet EN 71. So the products are legitimately able to bear a CE mark for conformity to the EN 71 standards, yet were still recalled because they presented risk that the standard did not cover. That could apply to any other product that is covered under a CE mark. If there are other features that standard did not meet with, it's going to be a substantial product hazard. And the interesting thing is, I mean, think about it. This is why standards evolve, is because as products evolve, things happen, mistakes happen, and the standards get better. You don't want to be the source of one of those mistakes that leads to a reason to change the standard. So that was kind of my take on it. And Geraldine, I don't know if you have a different take from the court standpoint.
Yeah, I mean, things very rarely end up in court. They normally get settled out of court, to be honest. And it does depend on what's happened, right? We can't really tell all the time. However, the one thing I think people don't understand with the CE mark, and not necessarily don't understand, maybe miss, is the CE mark is not just saying we've tested to EN71. There's a huge part of it called conformity assessment, which is basically manufacturing control. And that's where a lot of the issues arise. So you might have tested it and it complies to EN71, but if you're making 2 million of them, how have you ensured the consistency throughout production? And that's something that needs to be factored in, at the beginning and in the risk assessment. So I hope that answers the question. But I agree with you, Don. It's yes and no, kind of.
And I see a new question about in the US, have you received certification for your products via ASTM? Does that suffice as proper due diligence? Again, same answer for me. I actually sat on the ASTM standards committees for juvenile products for things like strollers and play yards and things like that, right? And we met on a regular basis in order to discuss things. One of the things that we discussed in every single meeting are what are the incidents that have happened in the past since the last meeting or going back in history, and do we need to change the standard because of the incidents? When you look at the recalls that are out there for juvenile products, the vast majority of those products actually complied with the ASTM standards for those products. But because design and innovation far outpaces the ability to create standards, new designs come out, new features come out, and those designs and features have safety issues that the standards simply are not addressing. The entire reason the standards, the voluntary standards have gone to where they are is through instant analysis of companies that have made products that are dangerous, that have caused injuries to consumers or children, and the standards group finds out about it and puts in new requirements for that. That right there should hopefully tell you it's not enough just to meet the standards. Right?
Yeah, and as a legal matter, the courts have made it clear that standards are considered minimum, not maximum. And you can always have an argument that you should have designed it. You should have exceeded the standards and made the product safer than is required by the standards. And that's a good argument by the plaintiffs. There was another question in there about the EU serious risk definitions, and it may be just a typo in there. There was an A, B, C, and E. The question is, was there a D? I don't know. I didn't go back and look at the slide. You can look at that. Yep, A, B, C, E.
That person wins a prize. That was there just to make sure that people were watching the slide. So you win it. You win a prize.
And I'll answer the next. So we'll correct that on the slide. And then the next question was about the free webinar next week on PRISM. And there will Geraldine will put links and any other links we'll put in the slides. The slides will be posted tomorrow or Thursday at the latest. And so we'll get the links in there for you, both for documents and for the programs to put in there. I think that's the easiest way to do it. What I might do is maybe we'll even send a copy of the slides to all the attendees if our administrator can do that. But either way, just check back in a couple of days in the website, and I have got the link there. If you can go to the second to last slide, because I have the link where they can get their material. Okay, I have a oops. Let's see, do we have yeah, no, I think we dealt with the questions that came in. I have a question for both of you. The key to risk assessment is to evaluate hazards. But there's no way to know how do you identify hazards to evaluate. If it's a hazard that you've never heard of before, do you put that in your risk assessment? Now, for me as a lawyer, I'd say, hey, if you put that in your risk assessment, are you admitting that misuse is reasonably foreseeable? I'll give you an example. My old company made chainsaws. we learned that somebody was juggling our chainsaws while they were running. And they jury-rigged the chainsaw so it could run while they were juggling it. Is that part of my risk assessment? I now know somebody is doing that. Is that now a reasonably foreseeable misuse? So again, from my simplistic legal ways, I'd say, well, shoot, if I put that in a risk assessment, I'm admitting that's reasonably foreseeable. So my message to risk assessors is be careful about what you put in your risk assessment and the hazards you identify, because it may be so remote, you've never heard of it happening before. And so by putting it in the risk assessment, you might be admitting something you don't want to. Response from either of you?
Well, the language that I always read and what I also teach is reasonable foreseeable use and misuse. Yes, there's misuse, but there's also extreme misuse that you don't necessarily have to factor into. So it comes down to reasonable misuse and foreseeable use that you identify and address. And you tend to leave it at that unless there is evidence that that extreme misuse is taking place on a more regular basis, like in the example of lawnmowers, with people picking up a lawnmower to mow a hedge. That actually happened frequently, and that's why lawnmowers have the safety device now up by the top of the handle that you have to have that gripped and running, is to prevent someone from reaching down in the deck area. So it's extreme misuse until it starts becoming frequent.
Okay, Geraldine, do you have anything to add on that?
Yeah, I agree. And it's funny, I mentioned that in a training I did, and then somebody actually sent me a TikTok video or something of someone actually doing it. So people do that, I guess. For me, if it was me, I would want to be aware. And then you say, well, there's not much we can do about it, or the standard actually won't allow them to be, in use when they're throwing them around. I think for me, it would be something to be aware of. But there's only so much you can do. Otherwise, you just don't have the product or.
Yeah.
And you also run down the rabbit hole of, in that example, and Geraldine's right, the standard actually requires safety features on products that would prohibit that. Well, what if they defeat the safety measures and they tie a string around it, keep it running? Now you have an intentional action being taken to defeat a safety device that was put in. As far as I'm aware, there's no court in the land that would find a product company at fault if someone intentionally defeats a safety feature and then takes actions that puts them at risk. So
yeah, the courts have said that they recognize that everything is foreseeable, but you do not have to design out or warn or instruct about every foreseeable risk. It's reasonably foreseeable. Unfortunately, in a product liability case, the jury gets to decide what's reasonably foreseeable, not you. So it's something to consider as you do it. But I would caution against putting a totally unforeseeable risk, even if you know that somebody's done it. I'm not going to put chainsaw juggling in a risk assessment for a chainsaw, even though I have a videotape of a guy who actually was doing it on my company's chainsaw. I'm not going to put that in there. Let me ask you this. It sounds like we have inconsistent approaches to risk assessment between US, Canada, EU, UK. What does the company do? Let's assume they sell in all the regions. Should they take the most rigorous risk assessment process and do that, and just assume that it'll serve them well in all jurisdictions? Or should companies actually do different kinds of risk assessment depending on the jurisdiction?
Well, in my opinion, a risk assessment is a risk assessment regardless of the jurisdiction. Human beings are human beings. Human factors are human factors. You may have cultural elements that a consumer in a given country may react differently or engage differently with a product, but that should be factored into the risk assessment as far as the geographic location of the use. But a risk assessment is a risk assessment. Now, if you have specific requirements that must be followed, you have to follow the requirements within the jurisdiction. But as we talked about, US doesn't have any requirements for it. Canada, as far as I'm aware, does not have any written requirements around how to do a risk assessment. And even Europe, while they're the closest ones to having a written requirement on how to do it, they still don't have the formal, this is what you must have in it. So my answer would be, you do a proper risk assessment, you avoid a product having a substantial product safety defect, and then it doesn't matter because you have your documentation, you have your risk assessment. But if there are specific elements a given jurisdiction has, you're probably better off making sure it has those elements at a minimum.
Geraldine, quickly, do you have anything to say?
No, I agree. I agree.
All right, great. Well, yeah, inconsistent treatment of risk country to country is going to get you into trouble. So you really need to think about that. Even if you don't sell in that foreign country, I would argue, if I were a plaintiff's expert, that even you should employ the EU's risk assessment processes as so-called best practices in risk assessment, even though it's not generally used in the US that way, that there are procedures out there for doing it. So now, as this slide shows, you've got email addresses here. The slides, this is the link to where the webinar archive, where the slides will be posted in a couple of days. And so we encourage you to take a look at those and send them around to people. There'll also be a link to the webinar, a recording of the webinar, and a link so that anybody can have access to that. We appreciate your attendance. Thank you very much, Geraldine and Don. That was wonderful. Enjoyed it. And hopefully we gave you some useful information and at least made you aware of all the things that are out there for you to look at further, to study, and to make decisions about what you want to do. Thank you again on behalf of both Sedgwick and the Society of Product Safety Professionals. Thank you, and we'll see you the next webinar we do. Thanks.
Thanks, Ken.
Thank you. And I think we're going to turn it off. Loudon, are you going to stop?